Hi, this is Irina Shea, and this is part of our Wealth and Wisdom series. Today, we're going to talk about what if I move to another state? Okay, so I'm going to share my screen with some thoughts. All right, so first, we'll say that very importantly, estate planning is state-based law. Your estate plan is based in the state in which you are domiciled. That is your permanent residence. It's where you live most of the time, where you file income taxes, where you declare your residency. And what has been happening since COVID is that people are moving more than ever, and leaving the state. And they may not think about their estate plan in that process. They are also doing things like buying a test property or a vacation property out of state, to see if they'd want to live there, to see if they want to retire there. So you're no longer just living in New Jersey, you also have a place in New York, or you have a place in Delaware, you have a place in South Carolina or in Florida. You're testing it out. So what happens with your estate plan? You have to then revisit this. Okay, so state laws are different in every state. So if you did move, say, from New Jersey to Florida, Florida has very different rules. One, probate is lengthy, expensive, difficult, and everyone there does revocable living trusts. That's one example, okay? There are other southern states where that is also the case. Um, and you also want to avoid, at all costs, ancillary probate. So if you die in New Jersey with New Jersey property, you're dealing simply with the New Jersey courts in the home county where you reside. In our case, it's Bergen County. It's a relatively straightforward process. If, however, you have that second property in, say, Florida or New York, where probate is difficult, that is what's called ancillary probate. Ancillary, like on the side, but it's a much longer procedure for your kids who are going to be your executors someday to deal with this. So again, we want you to get ahead of it. Whether you fully move there or you're kind of bridging the two states, which a lot of people right now are bridging two states. They're kind of exiting one, but they haven't quite entered the other. It's unclear. So we absolutely have to make provisions for that. So what do we do? Some states have what are called payable on death deeds, New York, Maine, etc. We do not in New Jersey. Or we use revocable living trusts to hold the out-of-state property. We have to look at all these things holistically. So when we sit down with clients, we create what's called a whiteboard. It's like a blueprint from their estate planning intake. So we can map out solutions for all of this. But the day comes a couple of years later where you say, we're fully transitioning to that second state. Again, I'm just going to use Florida. That seems to be the most common. You would then need to see, when fully moving to a new state, we'll say Florida, you need to redo your estate plan there. That means finding an estate planning attorney or firm there in the state of Florida, because that is now your new domicile. It's your new domicile. And those laws are going to govern the disposition of your assets and incapacity documents like power of attorney and healthcare directives in that state, and they are different. So it's really important to transition. I know your financial advisor that's been helping you for forever can help you from anywhere, right? But estate planning attorneys are licensed state by state. So you would ask for a referral or find your own through your financial advisor, for example, in your new state to redo or refresh your estate plan. So I think a lot of people just sort of have the impression that once you create an estate plan, it's valid in all states. That is not the case. Unfortunately, it is more complex than that. But this video hopefully shed some light on it. So if you are in New York or New Jersey, we are licensed there and are happy to help. The way to do that is to go to our website, irinashea.com, and click on the Get Started tab. There are no charges for our initial consultations. Thank you.